want to, so thank you, appreciate all that we just heard. I just wanted to, for the sake of the record, read the Rhode Island General Laws provision subsection that says, under the Energy Facility Siting Act, which of course vests in this board the authority to oversee the construction, the siting and construction of major energy facilities, that Rhode Island General Laws 42-98-16A allows for suspension in the board's discretion and allows for the applicant to have a reasonable opportunity to remedy lack of compliance. I appreciate that the attorney for the town wanted to make a statement on the record, but we have rules that regulate what we do with authority of law, and that's what I'm looking at when I look at our rules that talk about tolling time limits and allowing the board it actually to even go back to the beginning of the statutory period if we so wish. So I do think in this instance that certainly a very significant, we talked about that last time, component of an energy plant is the water supply. And so we're missing, we discussed that, that's why we asked for this hearing, just to sort of review where we are. You've come into the hearing and chosen not to show cause for why we should not suspend, but in essence are agreeing with everyone that this process should not proceed when it lacks a water supply plan. So I think under our rules and our statute that the reasonable opportunity should be given to the applicant to plan. I do think that in any sort of indefinite or long-term protracted process is at a disadvantage to the applicant and to the folks who have the positions as stated like the town that approves this plan. But I think that a 60-day time frame to come back and give us a status update. The motions to dismiss have been continued. There's something we can take up later, and we've read all the pleadings for it again. So, I mean, that's where I am right now, thinking that under the statute and the rules, that the appropriate remedy is to suspend this process and ask the applicant to come back with those elements of the application that make it non-compliant and incomplete. So I would say, let me try to just frame up that I would be inclined to suspend this process to stipulate that the things that you articulated, that the town articulated in the October 5th letter are at a minimum things that we would need to see. Ask the applicant to come back with information and let us know when you feel the application is complete, at which time we'll take a look at that and other motions in front of us. I don't know, and I'd be interested to hear what you both, whether we want to leave that part open-ended until we get the 60-day update, because I know there's things that we would have to see in order to lift the suspension.
I agree that what we're charged with under the Act should be given
We can't hear.
that kind of...
Speak up.
I think that I agree that the matter should be suspended. I think we should limit it to the 90 days.
90 days. 60.
90 days, which was suggested by the applicant with the status update in 60 days.
Yeah, the applicant's running the process.
Let's talk more about the timeline. I do agree that we do need to have a status update after 60 days. And maybe we can, once we look at the status update, and hopefully we will get a proper status update saying that where we are. And then maybe we can, the board can further decide whether, how long the suspension should last. But it did not last for indefinite time.
Why should we not accept the applicant's offer of 90 days?
I will be open for that. I will be open.
Oh my God.
I'm against that, but still I will be open since the applicant itself has suggested a 90-day suspension. So I will be open.
Company rules, who elected them?
Madam Chair, can you just summarize where you are right now as we're thinking about the decisions we need to make today?
Yes, I think we're all in agreement that, in the applicant, that the application is not in compliance at this time. And the remedies that we have, or we can suspend it, or dismiss it. I believe it should be suspended. I think it should be for, a definite time period. I think the applicant having offered 90 days, that
They run the process.
So generous.
also agree that we want the status update in writing in 60 days. And we'll be in a better position to determine what else we would need at that point.
We could get the trust in the process.
And we already have given enough direction for the applicant through our October 5th letter that say that this states what elements we are looking for as part of the water plan. That's true, right?
Yes, and I think I'm also in agreement that the list that the parties have provided, at a minimum, is what we need to hear from the applicant.
So sounds like we're talking about a 90-day suspension with a 60-day status update. The letter that we're referencing, and I won't read them all, but talks about the source of the processed water, the type of source, the quantity, the quality, the transport, expected treatment, identification of a redundant contingent process, the proposed location of discharge, and things like that, just for the record or for people who haven't seen that letter. I think if we do that and we continue the motion to dismiss, we can expect that, I guess that would be January, mid-January, that we would be back either talking about why we should further suspend or perhaps, depending on what we're saying,
Merry Christmas.
motions to dismiss.
Yeah, Happy New Year.
Or perhaps reacting to a plan that we have in front of us. But at this moment, I don't think there's more that we can do.
Process state.
I agree with the observations of Board Member Janicoy.
That's a surprise.
The
governor will be
when I
proud of
said
you.
it was late in the process, I only meant by that, so we began this process, as you pointed out, in January, I believe, that we haven't begun the final hearings where really a lot of the evidence and the information that we have in front of us is going to be considered and vetted, and that's what I meant by that.
Shame on you. Shame on you.
So do we need to have a motion? Suspend?
The governor will be proud of you.
We trusted the process.
Please be
We
quick.
know who owns you.
Move that we suspend the proceeding for 90 days. In 60 days, we want to be provided a status updated in writing
Thanksgiving
from
and
the
Christmas.
applicant.
All we do is count their money.
And the applicant shall provide, ultimately, at a minimum, those items that are listed in the October 5th, 2016 letter from the town of Burrillville,
Shame on
town of
you.
Burrillville's council.
Shame. Give me a chance.
I second the motion.
Shame
All in
on
favor?
you.
Aye.
Aye.
Madam
What do you
Chair,
think?
am I correct that we're talking about calendar days, not business days? Is that correct?
Yes.
Thank you.
Council, is there anything further? Tom?
Maybe appearances.
Here we go.
Shame on you.
Very
Does
well.
the statute
Where is
support
it?
the applicant running the process? Because that's what we're
Wall
saying.
Street runs the Merry process. Christmas, Invenergy.
Yeah, we're moving to get our lives back.
Wins. Let's see.
The fix is in.
We We shall overcome. We shall overcome. We shall overcome.